Hi, this is Estates and Trusts online module about survivorship requirements for gifts in trusts. Alright, so what are we going to try to do? We'll try to explain why survivorship matters and identify ambiguities and survivorship requirements in gifts and trusts. We will also contrast the survivorship rules for wills with the ones for trusts, and we'll identify some common law preferences in construing trust interests. Okay, so just for background, remember when we had wills, the beneficiary had to actually survive until the testator died in order to take the gift. Otherwise, the gift lapsed. And we did have an anti-lapse statute or statutes that we looked at that create a substitute gift in that instance in some cases, but not all. And often the gift would just lapse and it would go to other people under the will. Now, in the case of a trust, can we really expect that the rules would be the same? In other words, is that the rule here, or is it still necessary to survive until a future interest becomes possessory? Well, for an inter vivos trust takes effect immediately, so presumably only living people are mentioned in it. But we still might have this question out there when it's time to actually take possession. If it's a future interest, did you have to survive until then? All right, let's take a look at Swanson versus Swanson. Now, George Swanson's will created trust in which his widow Gertrude had a life estate or a life interest, and then the remainder of each trust went to the couple's children, one trust for each child. First question, were these inter vivos trusts or testamentary trusts? I hope you said testamentary, right? Because this is George Swanson's will. That doesn't really make the difference here, but it's a muscle worth flexing, right? Practice noticing that. Okay. Now, there were two that mattered in this case. They're slightly different, but the item 4 trust provides, in relevant part, to my 9 children, herein above named, to be divided among them in equal shares, share and share alike. If any of my children should not be in life at the time of death of my said wife, the share of such deceased child shall go to his or her surviving children per stirpes. All right, and the item 5 trust said, the remaining assets shall be divided into 9 equal shares, 1 share for each of my surviving children, or for the then surviving issue of each deceased child of ours. Clear, right? Real clear. Okay, we'll move on. Now, one of the 9 children had predeceased Gertrude. His name was Benny. He left no descendants, but he did leave a widow, Peggy. Actually, her name was Laura, but she went by Peggy. So if Benny's remainder was vested, then it was an asset he owned at death, and under his will, it went to Peggy. If, on the other hand, Benny's remainder was contingent, then it did not go to Peggy. Instead, Benny's share would pass by intestacy and would be split up among his siblings. So was that vested or contingent? Well, now let's see. It looks contingent because survivorship seems to be a condition for a child to take. Right? We've got that language about not being in life and all that. On the other hand, it looks vested because both of the clauses start by dividing the property into 9 shares. Oops, sorry. Oh, I'm trigger happy here today. The condition seems to be added on like a but-if clause. Remember, we looked at these. It makes a difference in vestedness. Now, the court finds that the remainders are vested, but that there are 2 divesting conditions. Actually, the court calls this one condition: not surviving and leaving descendants. I think it's 2 divesting conditions, but the court kind of reads it as one, and not leaving descendants is part of it. Of course, now, this was before the movie The Descendants, so that's probably not what was motivating things. Benny left no descendants. So the court says he didn't meet the whole condition, and therefore the whole condition for divesting, and therefore his interest is not divested. Now, useful stuff from this case. What common law principles did the court cite? A couple of them. Ignore the number ones there. The law favors construing conditions to be subsequent. And the law favors the vesting of remainders in all cases of doubt. All right, let's look at this first one. If the law favors construing conditions to be subsequent. Now, if Benny's interest was vested, then the conditions were subsequent, and this principle is satisfied. So in other words, this is a condition that can happen to take it away from him, but it's not something not a hurdle he has to jump in the first place. In addition, the law favors the vesting of remainders in all cases of doubt. So if we have a doubt, we should treat Benny's interest as vested, not contingent. In addition, the law favors early vesting. Court says, construe words of survivorship to refer to the death of the testator in order to vest remainders. So if we have doubt, we should treat Benny's interest as vested earlier, and certainly should treat it as vested. The court again says that there's one condition subsequent, and that is predecease Gertrude but leave children who survive Gertrude. So since Benny didn't do that, he did the predecease part, he just didn't do the leave children part. Since Benny's interest is still vested, it goes to Peggy. And the court says, and this really fulfills the testator's intent of dividing the property among 9 families. Yeah, even though one of the families turns out not to be your family anymore. Okay. Okay, notice also that the will did not provide specifically for this situation. So the court says there really is no language that plainly manifests a contrary intent. Okay, when you see that, there is no language that. Note to self, make sure there's always language, right? Give the court something that doesn't lead to litigation, or give your heirs something that doesn't lead to litigation. Now notice this was a split opinion. Your casebook doesn't give you the dissenting opinion, but 3 justices disagreed with this analysis. And again, focus on this. The will can provide any distribution we want it to. Subject to the surviving spouse's elective share, of course, but any distribution we want it to. So think about, how would you draft this will to avoid this litigation? All right, I'm not going to answer that. That's for you to think about. I think this is one of the problems from your book. Tim and Kathy had no children, but each had several siblings. Tim's will created a trust. For Kathy for life, remainder equally to my surviving nieces and nephews. What are the problems that you see with this language? Think about it first before you look at the answer. For Kathy for life, remainder equally to my surviving nieces and nephews. Well, Kathy's life estate looks okay, right? Start with the easy part. Remainder to my surviving nieces and nephews. Well, surviving when, right? Surviving right now when Tim dies and the will takes effect, or surviving later when Kathy dies and we have to decide who we're going to start paying to? It doesn't say. It doesn't tell us. And which nieces and nephews? Now this is, we get into some definitional stuff here, but are we talking about the offspring of Tim's siblings? What about the offspring of Kathy's siblings? Both? What if there haven't been any nieces or nephews born? And would this include grandnieces and grandnephews? People get a little bit vague about how they use language, particularly in large families. There might be lots of cousins. Well, some of those might be cousins once removed, or they might be second cousins or third cousins. Here it's nieces and nephews. And if you're married, you know, if one of you has a niece or nephew, they likely call you Aunt and Uncle so-and-so, or Aunt and Aunt so-and-so. Right? So are you only talking about your biological siblings' kids? Are you talking about your spouse's kids? Um, who exactly do you mean when you say nieces and nephews? Okay, that's the end of this part, so I'll stop the video here. Thank you for watching.